Good morning. You should understand the proposed discussion. This is tip number 24, Penal Code, Indian Penal Code, BN Bharatiya Nyaya Sanhita, Section 96 of the IPC, and now 34 of BNS. Right of private defense. Right of private defense, right. It says nothing is an offense which is done in exercise of the right of private defense. It is right inherent in man. It is the first duty to man to help himself. The right must be fostered to the citizen of every free country. See, doctrine of private defense is founded on the following expediencies. Most important thing. This right of private defense is subject to onus. You have to prove under what circumstances you have defended your right. Number one, a person whose life is threatened by a grave danger need not wait for the state unless such aid is available. Right of private defense is protective or preventive and not punitive. Not meant for punishing the aggressors. However, punitive measures may result. Right cannot be availed of for the sake of self-gratification or to satisfy one's malicious and sadistic urges. The act of private defense should not be deliberate or retaliation for past injury. The right must be exercised when there is a real and immediate threat, not imaginary and remote. Reasonable apprehension of such threat. A fear that one might or will be attacked in near future will not justify exercise of right. The right commences as soon as reasonable apprehension of danger to body arises from an attempt or to threat to commit offense, though the offenses may not have been committed, and such right continues as long as apprehension continues. It is incorrect to say that a person should claim right to use force after he had sustained serious injury. So you need not wait that you have to exercise it unless you sustain serious injury. If the apprehension is real and reasonable, it makes no difference, then it is mistaken. The protective measures employed must be relative to the danger ahead. The violence used must be proportionate to the injury or threat to be averted and must not exceed such limits. However, in such situation cannot be expected a person minutely calculated the correct proportion of force to be used in defense. Right of defense ends with the necessity for it. Thus, a person exercising such right need not chase the fleeing attacker and then beat him. Then the law does not require that a person should not exercise right to self-defense. By running away, he can avoid injury. He should exercise it. Law does not require that a person placed in such circumstances should weigh the arguments for and against an attack in golden scales. The aggressor cannot claim right to self-defense. There cannot be private defense against private defense. There is no right of private defense under the code against any act which is not itself an offense under it. So when you are to safeguard your private, when you attack, the other man attacks you and claims private defense for him is not applicable. In case of free right, no right of private defense is available to either party. If an accused does not plead self-defense, it is open to the court to consider such plea if the same arises from material on record. The court can also consider even if you did not plead it. So kindly go through all these things. Best wishes.